Dr. David Shoebridge.
The O'Farrell government's first 18 months in office has seen a series of assaults on our civil liberties. Before they were elected, this government promised to end the law and order auction that has been a blight on New South Wales politics for more than 2 decades. It's safe to say they've already broken that promise. The extent of the attacks reveals a concerted and ideologically driven program to limit and remove fundamental rights from the people of New South Wales and shift power and control towards the police and the executive government. These are just some of the most damaging changes. In 2011, the expansion of Move On directions gave police an additional power to move on an individual intoxicated person. This law allows police to decide, based on their opinion alone, that a person is intoxicated and then force them from a public place. Historically, these powers have been used mainly against disadvantaged groups, and it looks like history will repeat itself in New South Wales. Then we have the Crimes Criminal Organisation Control Bill 2012. That's the reheating of the so-called anti-bikie laws that the High Court struck down in 2011. Those laws criminalise association rather than criminal activity itself. The New South Wales Bar Association and the Law Society have also strongly opposed this law on the grounds that it unfairly impinges on human rights in New South Wales. There was also the denial of official visitor access to those on preventative detention. This means that people held indefinitely in New South Wales prisons under anti-terror laws without charge will have no recourse to an independent external person to oversee the conditions of their incarceration. The government also introduced consorting as an offence as part of the suite of legislations introduced by this government to apparently address bikie gangs in New South Wales. In doing so, it reintroduced a version of these 1920s consorting laws that were at the time introduced to deal with razor gangs in Paddington. Again, this criminalises people meeting with people as opposed to real crimes. The government's also revived the laws against drunken disorderly conduct, again in a direct throwback to the 1970s, when the offence of drunken disorderly drew regular criticism and was finally struck off the statute books because of its unfair impact on marginalised groups. Not satisfied with that, we've got Mr O'Farrell removing the long-existing common law principle of spousal immunity. This change will make it a blanket rule that regardless of the circumstances, it will be a crime not to dob in your partner to the police. How does that advance our civil liberties? And one of the first actions this government took was the introduction of mandatory sentencing with the Crimes Amendment Murder of Police Officers Bill 2011. This change removed all judicial discretion for sentencing where the defendant is found guilty of having murdered a police officer. Murdering a police officer is a terrible crime, but mandatory sentencing does nothing at all to reduce offending and inherently leads to unjust outcomes. Then there are the anti-graffiti laws that are designed to force young graffiti accused straight into the courts. No discretion, no flexibility, no room for common sense. This alone will increase rather than reduce the terrible number of young people we have in prison here in New South Wales. This week, the government passed laws to expand operations for police sniffer dogs to all of King's Cross and all of the Sydney, the Hunter and the Illawarra rail network. This step will expose yet more innocent people to intrusive and humiliating public searches following false positives by dogs. We know the dogs get it wrong 80% of the time, but they expand the program. And not only that, it threatens the viability of the state's only medically supervised injecting centre that's saving lives based on evidence. More changes have already been slated. We've got the New South Wales government's plan to abolish one of the oldest principles in the legal system, the right of an accused person to remain silent under questioning by authorities. Under that proposed change, the refusal to answer questions could harm a person's defence in a later court case. The change has been sold as a win for victims. In reality, the change will put at risk the presumption of innocence itself. The risk in New South Wales is even greater because citizens here have no Bill of Rights to ensure they get a fair trial and no guaranteed access to legal assistance. The government has also announced they intend to bring in legislation to provide for indefinite detention of violent offenders who have finished their sentence to protect against future crime. Again, legal groups have spoken out strongly against this proposed change, identifying it as eroding the principle of the justice system that you can only be punished for crimes you've committed rather than potential crimes. It's likely these provisions will be used by politicians to seek to extend sentences in response to outrage at violent offenders being released, producing individual vigilante justice. Time after time, these laws are debated in Parliament, and the Greens are the only party speaking up for our fundamental rights and liberties. Perhaps the Attorney-General was right when he said there'll be no law and order auction under his government. Instead, it's become a civil rights giveaway.